Good morning, everyone. Welcome to the First District Court of Appeals. We have two cases set for argument today. I'll read the cases out, and if the lawyers would please identify themselves and their readiness to proceed. The first case we have set for argument is Endurance American Specialty Insurance Company versus Avectus Healthcare Solutions, and that's case number C230104. Good morning.
Christopher Ryan from McCormick Barstow here for the appellate.
Good morning. Pat Fredette as well for the appellate at McCormick Barstow.
Good morning. The second case that we have is Gig Smart Inc. versus Axel Hire Inc., case number C230109.
Good morning, Your Honor. Derek Ketch on behalf of the appellant.
Good morning.
Good morning, Your Honor. Charles Russ on behalf of the appellate.
All right, good morning. So everyone's here. If the attorneys for Endurance American would step forward. And Mr. Shen, would you like to reserve any of your 15 minutes for rebuttal?
Yes, Your Honor. 5 minutes, please.
5 minutes? Okay. I'll keep track of your time on the podium. When you have a minute left of your initial time, the yellow light will come on, red light will come on when you're out of your initial time.
Good morning, and may it please the Court, Andy Shen from the Kellogg Hansen firm for Appellant Avectus Healthcare Solutions. This is an insurance coverage dispute. The issue before the Court is whether the trial court erred in holding that Endurance has no duty to defend Avectus in the underlying Raymond action, and we respectfully submit that it did. I'd like to emphasize for the Court 3 points. First is that the standard governing the duty to defend is incredibly favorable to the insured. Avectus need only show that one of the claims in the underlying action is potentially or arguably covered by the policy. If there's any colorable reading of the policy that would cover any one of the claims in the underlying action, Endurance has a duty to defend the entire action. And here, the fact that Endurance chose to defend the action in the first place indicates that there is at least an arguable basis that the alleged conduct is covered by the policy.
But they provided this coverage with a reservation of rights.
Well, yes, Your Honor, they certainly did. I'd like to point the Court initially to the April 4th, 2016 letter that Endurance provided to Avectus saying that it would advance defense costs. This is at trial docket 33, FOS Affidavit Exhibit C. In that letter, it said that it would advance defense costs, and it also stated that, quote, "There are significant questions that remain as to whether the policy affords coverage for the claims." It said the same thing in an August 20th, 2019 letter, and that's an admission by Endurance that there are at least significant questions as to whether there's at least a colorable argument that the underlying conduct is covered by the claims. If the Court were to look at the actual language in the policy also very clearly covers the alleged conduct in the underlying action. The coverage provisions in the policy must be liberally interpreted in favor of the insured, and it covers both all consulting and administration in regards to the collection of healthcare insurance recoverables from insurance companies. It also covers any errors in conducting or attempting to conduct those acts. Now, part and parcel of collecting insurance receivables from insurance companies is determining whether there's other third parties, patients, insurance companies, tortfeasors, that have obligations to pay before an insurance company's obligations kick in. And that's because an insurance company is frequently secondary to other parties that have primary payment obligations. In conducting the business of collecting healthcare receivables from insurance company, Avectus must often reach out to these individual patients and, where appropriate, seek payment from those patients before collecting remaining amounts from insurance companies. And there's two portions of the policy that clearly demonstrate that Avectus, the alleged conduct here in the Raymond action, is covered. And the first is the FDCPA endorsement. The policy includes within its coverage Fair Debt Collection Practices Act claims. These are one of the claims that are asserted in the underlying Raymond action. The FDCPA is a federal statute. It applies only to attempts to collect debts directly from consumers. And by including those claims within the policy's coverage, the parties clearly contemplated that Avectis would contact and may collect payment from individual plaintiffs.
Can you explain a little, like, what is the deal with that part of the policy? Because I was a little confused on, your opponent is saying it doesn't apply, you're saying that the Fair Debt Collection Practices Act is those kind of acts are included, so what happened with that?
So the policy originally had an exclusion for Fair Debt Collection Practices acts. The parties then entered into an endorsement. They entered into that endorsement on February 26, 2016, which was after the claims were submitted to endurance to cover the suit. That endorsement removed the FDCPA exclusion. And as a result of that endorsement, the fair implication of that is that FDCPA claims, the parties intended those claims to be covered.
So is there anything in the record showing why that endorsement went into effect?
Well, there's nothing specifically in the record showing why the endorsement went into effect, but I would like to direct the court to the April 4th, 2016 letter that Endurance sent, where it said it was providing coverage. And it said it was providing coverage, quote, given the recent removal of the FDCPA exclusion. So Endurance itself said that given the parties' agreement to remove the FDCPA exclusion, it's going to provide coverage.
But, okay, could it have been, theoretically, could it have been that it was removed because it was redundant? Because, you know, there's a Supreme Court case saying that that statute is a consumer protection statute, and that is already excluded from the policy.
Well, there would be no reason to enter that endorsement in the first place if it's redundant. If the court holds that the FDCPA claims are not covered, then that endorsement has no effect whatsoever. It's a dead letter. Now, you can give effect to both exclusions K and T, which are the Unfair Trade Practice Acts or the Consumer Protection Act claims, and the endorsement, because those separate exclusions K and T would cover the Ohio Consumer Protection Act claims. Those claims are clearly excluded. But then the parties contemplated, well, what about these FDCPA claims? Are those excluded? And they specifically entered an endorsement permitting those to go forward.
But again, there is a Supreme Court case saying that the FDCPA is a consumer protection statute that prohibits certain abusive, deceptive, and unfair debt collection practices. So it says it's a consumer protection statute. It says it prohibits abusive, deceptive, and unfair debt collection practices. How is that not encompassed by the exclusions?
Sure. There's no question, or we don't dispute that the FDCPA is a consumer protection statute. What we are asserting is that the endorsement 20, is a specific statement that trumps the more general language in the exclusions. And we've cited several cases to the court on that specific issue. We cited the St. Paul fire case out of Mississippi. The endorsement is a specific statement that controls even if it conflicts with other language in an exclusion, even if it conflicts with other language in the policy. Here again, if the court doesn't allow the FDCPA claims to be covered, that endorsement's a complete dead letter. It's being read out of the policy, and it's outside of what the parties intended when they entered into that.
So this is an exception negotiated by the parties?
Yes.
Basically?
Yes, it is. And not only is it an exception negotiated by the parties, it's an exception negotiated after the claims were submitted to Endurance. Again, it was negotiated February 26, 2016. The claims were made, Avectis made its claims September 11th, 2015. I'm happy to address any of the arguments about the exclusions. The point I'd like to make there, though, is that it is black letter law that exclusions must be interpreted very narrowly, and that Endurance bears the burden to show that an exclusion clearly and unmistakably apply. So Endurance bears the burden to show that every single claim in the underlying action is actually excluded. Now, we pointed to the FDCPA claims, which are subject to specific endorsement. I'd also like to direct the court to exclusion A of the policy, which specifically addresses fraud claims. And that exclusion says that fraud claims are excluded only, quote, if a final and non-appealable judgment or adjudication adverse to such insured establishes such conduct. All right, so an alleged fraud is covered by the policy. The only thing that is excluded is if a court adjudicates that there is an actual fraud, which of course hasn't occurred in this case. In the underlying action is an alleged fraud. There is a settlement in principle in the underlying action. There's not going to be an adjudication, a final adjudication, unappealable, that there was fraud, and so that claim is covered as well.
So you're saying the common law fraud claims are not excluded?
Yes, Your Honor. There's a specific exclusion, exclusion A, that covers.
What about K&T?
K&T covers on its face unfair trade practices and Consumer Protection Act claims.
False and deceptive unfair business practices.
Yes, Your Honor. There's 32 specific exclusions in the policies. The parties knew how to exclude specific claims and specific sources of damages. They address fraud in exclusion A. They address consumer protection in exclusions K and T.
So you don't think that K&T could encompass an exclusion for a fraud claim?
Again, the principle that applies is that you look at the specific language addressing the specific claim, and that trumps more general language.
So because A specifically talks about fraud, then K&T don't apply to fraud?
Not only that, but also a fraud claim can go forward even if the underlying plaintiffs don't prove a consumer protection or unfair trade practices claim. There are different elements to a fraud claim than Consumer Protection Act claims. For instance, Consumer Protection Act, unfair trade business claim, you have to prove that the conduct is likely to or did mislead a substantial proportion of the target population. That's not an element of a fraud claim. I see the yellow light is on. I would just like to address very quickly the recoupment arguments. The court doesn't need to reach the recoupment arguments if it finds that a duty to defend exists. But if it does reach the issue, we've cited case law from Mississippi, the Mississippi Supreme Court, as well as the Chiquita decision from this very court, saying that there's no right to recoupment even if there is a reservation of rights. In Mississippi, recoupment is barred under the voluntary payments doctrine. In Chiquita Brands, the court held that no implied contract exists when an insurer advances defense costs subject to a reservation of rights. The Chiquita Brands case has a very narrow exception for restitution, but the court held that only applies when the trial court specifically orders the insurance company to advance defense costs. The insurance company advances defense costs, reserves its right, and then the appellate court reverses the trial court. That's obviously not what happened here.
Okay.
Thank you, Your Honor.
Thank you.
May it please the court, my name is Christopher Ryan. I'm here for Appellee Endurance American.
You may want to speak louder.
Oh, I'm sorry. I'll speak as loud as I can. I'm here for Appellee Endurance American. My name is Christopher Ryan. First, I'd like to rebut a couple of things Mr. Shen stated. First, he stated that the reservation of rights letter sent by Endurance was effectively an admission that there was coverage, or at least a duty to defend in this case. That letter stated that there was a strong belief that there was no coverage, but at the same time, out of an abundance of caution, they used those words, out of an abundance of caution, reserved rights and agreed to provide a defense in the matter. So if a reservation of rights is effectively an admission of coverage, a reservation of rights is not effective. A reservation of rights reserves nothing in that case. That would write out the entire practice of reservation of rights. Second, I'd like to discuss the FDCPA issue and the FDCPA exclusion. Now, Avectus is correct that the policy was issued initially with a specific exclusion for FDCPA claims. And Avectus is also correct that the FDCPA claim exclusion was then removed by another endorsement. What that does is return the policy back to its starting point without the exclusion. Mr. Shen stated that it was a negotiated exception to the exclusions K&T for the FDCPA claims to be covered. There's no evidence in the record of such a negotiation. There's no evidence developed by Avectus that there was a negotiation. If they believed that there was a negotiation and that the FDCPA claims were specifically meant to be covered, they could have developed that in the underlying court.
So wait, so there was initially an exclusion that specifically referenced the Fair Debt Collection Practices Act as being excluded?
Correct.
And then later, what happened? What happened with that?
That exclusion was removed at the request of Avectus.
Okay.
And it was removed after the claims, is what I understood.
Correct.
And you're saying that the removal of that had no effect?
The removal of that had the effect of removing that specific exclusion, but the removal did not have the effect of creating an implied exception to exclusions K&T, which is what Avectus contends. Avectus contends the removal of an exclusion creates an implied exception to another exclusion. Endurance contends that's not the case. Endurance contends that the FDCPA exclusion was in fact redundant, and its removal in this case, in this instance, had no effect because the exclusions K&T did exclude those claims.
Can you talk to me about the timing and what effect that is, that the endorsement removes that exclusion after the claims were filed?
Well, I don't think there's any actual effect that the timing has. The claims were filed, the endorsement was in effect, the endorsement applied, obviously, to the FDCPA claims while it was there. It was removed. The record doesn't indicate specifics as to the reasoning.
But there had to be a reason. I mean,
Correct.
right? I mean, don't you, I mean, obviously, the exclusion of this particular type of claim was important, and it was discussed.
Well, it was important in two respects. I mean, right, correct. Well, it was important to Endurance to include the exclusion in the first instance. They
Right.
wanted the claim excluded.
Right?
Okay,
And then it was important after they got sued to get rid of it.
Well, it was important for, well, I don't want to argue what was or wasn't important on behalf of Endurance. They'll state that for themselves. And again, the record doesn't indicate what, their reasoning or what agreement there was.
But it would be logical to conclude that that would be their reason, right?
Well, it could be their reason, but at the same time, it doesn't reflect an agreement by Endurance that they would remove it for that reason. It could be simply an accession that, okay, they want this removed. Well, we've got this other exclusions K&T that also apply. It's redundant, so therefore, we'll remove it.
But no one's arguing parole evidence, right?
No,
So what the reason was, is that relevant?
excuse me?
The reason of why, is that relevant?
No, the reason isn't relevant. What's relevant is the language of the policy that sits before us.
That's what I was going to say. Seems like your position is really contract interpretation.
Exactly. That's exactly the position. And the position is that exclusions K&T squarely address the FDCPA claims. Now, briefly.
But I do want to go back to Judge Bach's question, because I'm also perplexed by this. Why would it, if there was a change after the claims, what relevance does that change actually have, if any?
Well, I would say no relevance. I mean, the policy as it stands without the exclusion is what the policy states. And the policy without the exclusion, whether that exclusion was removed before the claims, after the claims, doesn't have any effect because the policy clearly excludes the FDCPA claims under exclusion K and T, which are unimpacted by this kind of two-step with the specific FDCPA exclusion.
Let me word this a different way, and I'm hoping that I'm capturing what you're asking, Judge Dias. So, do we look at the policy as it existed at the time that the claims were made, or do we look at it as it evolved?
Well, I think that's a fair question, but I think that Endurance's position is that the policy, as it stands now, as it stands even after the removal of the FDCPA exclusion, still excludes the FDCPA claims. Essentially, I guess the position is that it doesn't matter because the exclusions K and T already apply. You don't need to do that kind of forensic analysis of the timing of the withdrawal of the exclusion because the K and T apply.
Thank you.
I'd also like to address the fraud.
Before you go there, can I focus you in?
Sure.
Okay, so Mr. Shen, in his argument and in the briefs, suggest that contacting these patients' attorneys was indeed attempting to collect from insurance companies. Because when somebody is injured, say, in a car wreck, there is going to be an insurance company paying out for their injuries, correct?
Sure. Yes.
Okay, so their argument is that that contact is actually attempting to collect from insurance companies. Can you address that, please?
Yes, I certainly can. So essentially, Avectis's kind of position on this seems to have evolved. When Avectis applied for the insurance policy, they stated that they are not a debt collector, that they don't collect debts. In the course of this litigation, the underlying litigation, I'm sorry, Avectis claimed that exactly what you're stating. It was simply contacting health insurance consumer patients in order to see what third-party liability there might be. Then Avectis, admits in its brief later that it actually might collect payments sometimes from these patients. While Avectis claims that it was simply contacting insured patients for the purpose of determining third-party liability, I mean, that exact issue was argued in the underlying case, and it went to the Sixth Circuit. The Sixth Circuit found that actually, no, that's not what Avectis was allegedly engaged in here.
Well, hold on, that was on a motion to dismiss, right?
Correct.
So it was looking at the allegations, whether the allegations were sufficient.
Correct.
Okay.
Correct. So,
there was-
sorry. Right.
It wasn't like a factual finding. They
No,
just
no.
said the complaint was enough.
Correct. And it was a characterization of the complaint and the allegations of the complaint.
Just the allegations.
Right,
yeah.
correct. And that's important here because the allegations of the complaint inform, in the first instance, the duty to defend and whether there's, coverage in the first instance.
But that is the question, though. Is it the allegation of the action, or like what they're alleged to have done, which is sending this correspondence, or is it the plaintiff's characterization of that as being illegal? I mean,
Not sure
well, they sent correspondence, right?
correct. They sent the letters of
And
protection.
the plaintiff is saying that this was a violation of a bunch of different laws.
Correct.
So obviously they're going to have a defense to that.
Correct.
You've mentioned that. I don't know what's in there. I'm getting confused. What's in the record, what's not. We will not consider anything that's not in the record.
Understood.
But they sent a letter. So the fact that they sent a letter, their argument is it was in conjunction with these professional services that should be covered.
Correct.
So, I mean, that's the thing, is this, the action of them sending this letter, is that covered?
The short answer to that is no, and I'll explain why.
Okay.
The action of them sending a communication broadly, is not really what's at issue. What's at issue here is what the specific allegations are regarding these letters of protection sent to insured patients and the facts of those letters of protection that are in the record. Now, these letters of protection were sent to insured patients, and I think it's fair to ask protection from what? And the protection was against direct collection attempts being sent to collections. And in fact, that was the language the letters of protection used. This will prevent you from being sent to collections. And in order to get that protection, the patients had to pledge proceeds from judgments or settlements. And the Sixth Circuit determined that, that pledge of any proceeds from settlement or judgments was the patient's own money. It wasn't limited to medical fees that the hospital might have incurred. It potentially encompassed pain and suffering, lost wages, all sorts of things. It was essentially a direct attempt, or at least allegedly, and as far as the letters of protection reflect, which were in the record in the underlying case, they were a direct attempt to collect from insured patients. And that's really the source of Avectus's purported liability here. Now, I might have a little bit of time left, so I'd just like to briefly comment on the fraud exclusion that Mr. Shen brought up. Now, Endurance never claimed that Exclusion A applied in this case. Exclusion A admittedly doesn't apply in this case, but because there's never been a finding of fraud. But fraud requires a material misrepresentation, a deception. Exclusions K&T exclude coverage for any actual or alleged false, deceptive, or unfair business practice. Now, that necessarily means that if I allege that you've engaged in a fraudulent business practice, you've engaged in a deceptive business practice. That's clearly excluded by exclusions K&T. Now, I'm getting the wrap-up button, so I'd like to briefly note that I think that Endurance slightly, or more than slightly, mischaracterizes this court's decision in Chiquita with regard to recoupment. In that case, the Chiquita court, this court, found that restitution applied where A, the insured demands performance and it was reasonable to accede to that performance, and 2, the insurer reserved the rights to recoup on the subject. Now, in that specific case, the court found that it was reasonable to accede to that performance because there was a lower court finding that was eventually overturned that there was coverage. But in this situation, obviously that's not here, but the reasoning still applies. The insured has demanded performance. Avectus has been very clear that it demanded performance, and in order to avoid a bad faith action or similar complications, it was reasonable for Endurance to accede to that performance. I see my time is up. Thank you.
Thank you very much.
Yeah, I'd just like to
5 minutes.
address a few points that Mr. Ryan made, just to clarify the timeline that happened here. The policy was made May 27th, 2015. The claim was made under the policy September 11th, 2015. After that, an endorsement was entered February 26, 2016, but the endorsement was made effective April 9th, 2015. So to answer the court's question, the policy in place at the time the claim was made includes the endorsement because the endorsement was made retroactive. And the endorsement is incredibly important for two reasons. Not only because it shows that FDCPA claims are not excluded under the policy, but the endorsement also, the inclusion of the FDCPA claims goes to whether the underlying conduct was, quote, consulting or administration in collection of healthcare receivables. Because the FDCPA only applies to attempts to collect from individual consumers, the fact that that endorsement exists removing the FDCPA exclusion meant that the parties knew that that's exactly what Evectus was doing. In order to collect from healthcare insurance companies, it had to first contact other parties that had primary payment responsibility. That included patients, that included other tortfeasors, that included other insurance companies for those tortfeasors. I would like to address the April 4th, 2016 letter, and the court can read that letter for itself. There's two portions of that letter that are pertinent. The first is that endurance itself says that substantial questions exist as to whether there's a duty to defend. At a minimum, that's an admission that there could be colorable arguments that the claims are covered by the
Then how would
policy.
a company ever reserve rights then?
Well, the point here is that you can't reserve rights in Ohio or Mississippi under the law. You get certain benefits from advancing defense costs. And once you get those benefits, including avoiding a finding of bad faith, participating in the litigation, help in selecting the attorneys that defend the case, participation in settlement, participation in case strategy, once you render those benefits, you can't recoup that.
What case are you relying on for that in Mississippi?
The Colony Insurance, well, three cases, Your Honor. The Colony case, which is a Mississippi Supreme Court case. That, of
Okay,
course,
but
had to
that
do with-
one is distinguishable because that case involved a voluntary payment, and it was a voluntary payment of a settlement demand. That's a different situation here.
I don't think it is, Your Honor. Both are voluntary payments. There's no difference between making a settlement demand payment and advancing defense costs. I think endurance has argued that there is a difference because the duty to defend, quote, immediately attaches once a request is made. But that duty only attaches if there is an actual duty to defend. If you're in the recoupment realm, then necessarily there's no duty to defend there.
But an insurance company is basically walking a really fine line here. Either they forward these defense costs and they provide the defense, or if they happen to be wrong and they don't do it, then they have a bad faith claim.
Yeah.
So I feel like you are completely saying that, reservation of rights has zero meaning ever.
Well, the courts in Mississippi and Ohio have said that the insurance company can do three things. The first thing is that it can write into its policy the right to recoupment if a court finds there's no duty to defend. The second thing it can do is before it provides a duty to advance its defense costs, then it can enter into an express agreement with the insured that if a court later finds that there's no duty to defend, then you get the right to recoup. The third thing the insurance company can do is immediately file a declaratory judgment action. That's not what happened here. Endurance, the claim was made in 2015. Endurance waited 4.5 years, 5 years, to file the declaratory judgment here in 2020. During that entire period, 5-year period, it reaped the benefits of advancing defense costs, participating in the defense, participating in the settlement negotiations, participating in the case strategy, getting confidential information. Once it reaped those benefits, now it's claiming, we want our money back. And that's not what the case law provides. Thank you, Your Honor.
Thank you. Thank you both for your arguments today. The case is now submitted, and we will issue a timely decision. Have a good rest of your meeting. All right, next up is the Gig Smart versus Axel Hire case. Mr. Hush, would you like to reserve some rebuttal time?
Yes, sir, 3 minutes.
3 minutes, okay. Oh, and before we get started, there was, I believe, some correspondence from our administrator on the exhibits, and we're hoping that you get that resolved today.
I think our respective colleagues are working on making sure that gets taken care of today.
Okay, great. Thank you so much.
Thank you, Your Honor. May it please the court. Derek Hecht on behalf of appellant Axel Heyer. This case involves two out-of-state companies transacting business out of state. The dispute has no connection to the state of Ohio, and the only potential basis for personal jurisdiction over Axel Heyer is a form selection clause in an online, unsigned contract, of which there was a single piece of evidence relied upon by the trial court to find that that contract had been executed.
Now, you would agree that those contracts are typically held to be valid, right? I mean, you litigated this issue, and you're saying that there was no proof that your client actually signed up. And this is a situation where, just by virtue of signing up and getting a password, you agree to terms and conditions, right?
I think that needs some clarification.
Okay.
So they can be valid.
Okay.
Browse wrap, click wrap, sign up wrap can all be valid. But what they require is either actual or constructive notice of the terms of the agreement. And before it found personal jurisdiction, the trial court had to find that that agreement existed, that that notice existed. And it was GigSmart's burden to prove that that existed.
And just so, and you can clarify this, but just to understand how this works for GigSmart is when a person goes on the website to sign up initially, the terms and conditions show up, right?
No.
Okay, so tell me how it works.
Yeah, and it is confusing, and it's
Okay.
confusing because GigSmart changed their story 3 different times about how Axel Heyer allegedly signed up for this service. So first they said, you used our website, and our website has our terms and conditions. Then they said, well, no, actually, you didn't visit our website. You visited our platform, which is a separate website, the GigSmart, the Get Workers site.
Okay.
That site has a sign-up process that involves many steps, many pages you have to click through. They contend that on one of those pages, there's a single line that says, by continuing to sign up, you agree to our terms of service, which are linked but not displayed on that page.
Okay, and that's okay to do, right?
It can be.
Okay.
It depends on how those terms are displayed and whether they're conspicuous enough to give a user reasonable notice that the terms and conditions apply.
But the argument that your client made below is not that they weren't conspicuous enough. Your client said that they never went to that platform at all because they signed up over the phone, right?
Both arguments were made.
Okay.
The initial argument is that's correct. We never went to that sign up page because GigSmart provided us with credentials.
And that's what you're arguing on appeal.
That's what we're arguing on
So
appeal.
the idea that it wasn't conspicuous enough is not even brought to us, right?
We haven't raised that as an issue
Okay.
on appeal because it's a very factual issue that the trial court deserves deference to.
Okay.
There's enough in front of the court already with the issues we have, so we didn't want to load you with more. But so stipulating, or at least moving past that issue as to whether those terms were conspicuous or not, the court still needs to address and make a finding as to whether Axel Heyer visited that web page and clicked through that page where the terms and the link to the terms of service were contained. And the single piece of evidence relied upon by the trial court, single piece of evidence cited by GigSmart in his opposition, is a document purporting to show the IP address of an Axel Heyer employee was used to sign up for an account. That evidence doesn't exist.
Well, I thought there was a little bit more evidence. I thought that, okay, for example, Mr. Contino testified that Moore Leach sent an email to Axel Heyer at 3:53 p.m. the day of that conference call. The email was opened at 4:02 p.m., and then the account was created at 4:04 p.m., and at 4:20, Axel Heyer posted his first gig. So is that not evidence?
No, Your Honor. It doesn't show who created the account. It's undisputed that there was a conversation about the account creation, that it occurred on that day, that an account was created that day, and that it was used that day. Axel Heyer's contention is the credentials for that account were provided by GigSmart over the phone. GigSmart came to court and said, no, we have conclusive evidence. We have IP address evidence that the person that signed up for that account was located in California.
Okay. But also, the trial court found that your client's witness was not credible. It specifically found that she was not credible. Are we supposed to dispute that? Are we supposed to find that she was credible?
You can throw her evidence out. You can throw her testimony out entirely. It's GigSmart's burden to prove that jurisdiction exists here. And this is exactly what the trial court did, is it flipped the burden to Axelhire to disprove that it was the one that signed up for the contract.
It seems to me that what you're arguing, obviously, correct me if I'm wrong, is that the only way that they can make to prove their case here that somebody from your client's company actually went to the website to sign up was if they had like an IP address or something.
No, Your Honor.
What else could they have done in this case?
So Mr. Lau testified on behalf of Axelhire at the hearing. And he said after this whole dispute, after the litigation started, he went onto the website, he went to the Get Workers page, and he signed up for an account. And he received a confirmation email that he had created that account. GigSmart didn't have one for the alleged account that was created by Mr. Murphy that's the subject of this dispute. GigSmart didn't have that. They didn't produce it. There was no other computer evidence that Axelhire had visited that page, had clicked through that page, or anything of that nature to show that Axelhire was the one that had signed up for the account.
So the email would have done it.
An email certainly would have been evidence, and
Okay.
given the burden we have on appeal here, that potentially would have resolved the issue. But they didn't have it. They had a document purporting to show IP address that they admitted didn't show IP address.
But they also had testimony that they do not create accounts other than in situations that are not relevant to this case.
Mr. Coutinho testified that that's not their typical practice, and Mr. Oakes testified that that's not their typical practice. They didn't say they never do it, and as Your Honor noted, they do it. They do it
But
the
in
context of-
situations that are not relevant to this case.
They do it in what they call managed service relationships. So first they said they never do it. Then they said we do it in this instance. So the fact that it may be their practice not to do it, the practice of two individuals that were not involved in the account creation process, that doesn't satisfy the burden to say that that's what was done here.
But taking all of this together, could the trial court not, could a reasonable person not have found that that was sufficient evidence?
We don't believe so, Your Honor. The burden was on GigSmart, and it's not on Axelhire to disprove the account creation. You need some affirmative evidence of account creation, and it's as simple as an email. It's as simple as a witness testimony saying we did this. It's as simple as computer records.
Well, simply because it wasn't the evidence, the most convincing evidence in the world, but there were these emails, there was this testimony that doesn't happen, and there was the IP address, and I know that you dispute that, but taken together, it might not have been the best, but that wasn't enough?
No, Your Honor. None of that was evidence of account creation. It was evidence that a relationship was entered into. But the critical question is who created that account? Because to circle back, the question is, did Axelhire go to this web page? Did it view this link to the terms and conditions? And were those conspicuously displayed? And there's no evidence that happened. We demonstrated during the preliminary injunction hearing, you can bypass that page. After GigSmart testified that you have to go to it, you have to see it. And then GigSmart testified that 1,000 people used it, but that's not true either. 1,000 employees used it. That's not true either. GigSmart continued to change its testimony, and even if that weren't a case, even if it's not creating a question of fact by its own contradictory testimony, it shows that the testimony of the witnesses was not credible. It lacked foundation. It was hearsay evidence. It wasn't admissible evidence on which the trial court could have properly found that notice had been provided to Axelhire. But even if we move past that, we say that the forum selection clause was entered into, the next question is that forum selection clause reasonable?
And I just want to kind of cut to the chase here and have you tell me why this Ohio Supreme Court case, Kennecorp, why that doesn't apply, and why you're telling us that the Barrett case instead would apply.
They both apply, Your Honor. Kennecorp says that a forum selection clause in a commercial transaction is presumptively valid unless there's evidence of fraud, overreach, unreasonableness or unjustness.
Right.
And Barrett provides the test for how you determine reasonability. And there are multiple Ohio courts that use the Barrett factors, even in the commercial context, to determine whether a forum selection clause is reasonable. And no case cited by either party finds that when there's no connection to Ohio, when the parties don't live there, when the transaction wasn't conducted there or executed there, that an Ohio forum is enforceable.
Then tell me, I mean, Barrett came out in 1990 and Kennecott came out in 93, but they don't even talk about the Barrett factors in determining reasonableness.
Kennecott didn't need to talk about that because I don't think it got that far, and subsequent decisions have talked about that. And I'll just point the court to this court's decision, the First Circuit's decision in Fifth Third Bank for Celebration Suzuki. That's a 2011 case, and that was a case cited by GigSmart in its opposition brief. And that was a case where the court said, we have a commercial transaction between two entities, and we need to determine whether it's reasonable or not. And this court said, arguably it would be unreasonable if neither party, it would be unreasonable if Fifth Third Bank brought suit in a forum where neither party had a nexus or relationship. That's the closest we have, because typically businesses don't do this. They don't designate a forum that has no connection to the dispute or to the parties.
Well, there is some case law saying that when there's two commercial entities, that you don't even get, it's reasonable, period.
That's not correct, Your Honor. It's prima facie valid, but may still be invalidated based on unreasonableness.
There's a presumption of validity.
Yes.
When you're dealing with two commercial entities.
Yes. The preferred capital case, Kennecott said there's a presumption of validity, but it can be overcome. And this court suggested in Fifth
And
Third
it
Bank.
presumably will be overcome with the Barrett factors.
That's correct, Your Honor. That's the test. That's if you were looking at overcoming the presumption based on unreasonability, you would apply the Barrett factors. And whether you strictly apply the Barrett factors or apply them as a guideline, either way you can't reach reasonability here. All of the Barrett factors turn on connection to the forum. This court suggested that when there's no connection to the forum, it's invalid. Other districts, it's an unusual fact pattern, as the Lang court mentioned. So there's not a lot of case law where parties have designated a remote forum that has no connection.
Well, apparently it had a connection at some point, right?
Before this transaction was entered
Wasn't
into.
GigSmart they were from Ohio?
Yes, originally.
Okay.
But not at the time this transaction was entered into. It had
Right.
been several years since they had given up their Ohio corporate status, designated themselves as a Colorado-based, I believe they're incorporated in Delaware, no connection to Ohio.
How does RC 2307.39 come into play with this?
It doesn't, Your Honor. That's
Okay.
a test for, it's a rule of contract interpretation, of contract construction, but it can't supplant the requirement of due process for personal jurisdiction purposes. That's a separate analysis. No court, since it was enacted, has held that that overcomes the test laid out in Kennecott, which goes back to U.S. Supreme Court jurisdiction in Bremen. And Bremen is notable, too. That was a case that involved two international corporations, and they were dealing in an international shipment of goods. And the court said the forum selection clause in that case was reasonable, but it distinguished it from the case here. It said this is not a case where we have two locals in a local dispute designating some remote alien forum. That would be very different. So even they called out the danger of the arrangement that GigSmart tries to enforce here. Other courts across the country, there's a New York case, U.S. Merchandising, Inc. versus L&R Distributors, Inc., which again applied a prima facie validity to the forum selection clause at issue, but then said, essentially ran through the Barrett factors, even though they don't have the Barrett factors, and said, there's no connection to the forum here, so we're not going to enforce that. That wouldn't make any sense. And that's exactly what we have here. And there's a danger to allowing that. If you just allow any two corporations to designate any law that they want, you're going to have people litigating all over the place. And it's a huge infringement on state sovereignty, on principles of judicial comity, to allow one forum to reach into another state, the citizens of another state, a transaction that occurred in another state, and then litigate that case in their own state. And it can be used cynically, it can be used maliciously. In the case at bar, Axel Hire contends that this underlying direct hire provision that's at issue is invalid because it violates California's prohibition under Business and Professions Code 16600 on non-competes and restraints of trade. And we cited 3 different cases that show that when you impose a penalty like this, it's invalid.
That goes to the I mean, that's what would go to arbitration, right?
Eventually, yes. But the reason why the court has to evaluate the reasonableness of the forum selection clause and why one of the Barrett factors is choice of law is because when another state has an interest in enforcing their own laws, then that should be given great deference, and that court should be allowed to litigate that issue.
And I let you go way over your time, your initial time.
Am I over my time? The light has not come on.
I know, because I was absorbed with your argument, but if my colleagues have additional questions, okay, then
Thank
I
you,
will
Your Honor.
reserve
I'll
the rest
reserve
of
my
your
time
time for rebuttal.
Thank you.
Good morning. May it please the court, Charles Rust on behalf of the FLE. In essence, Axel Hire is asking this court to substitute its judgment for that of another in 3 distinct ways. The first way is they're asking you to substitute your judgment for that of the trial court as to its weighing of the evidence and its determination as to the credibility of witnesses. The second way is it would like you to substitute your judgment for that of the Ohio General Assembly when it enacted revised code 2307.39 in 2011. And then the third way, it's asking you to deviate from the established legal principle that an anti-suit injunction is the appropriate remedy to enforce a forum selection clause in a contract. So on that first issue, we have 2 sophisticated commercial entities, both of whom do business nationwide, as admitted in the trial court record. The trial court's decision was based on a preliminary injunction hearing conducted December 14, 2022. It heard live testimony from witnesses. Evidence was presented. Axel Hire presented evidence of its sign-up process, which includes a login page where a hyperlink to the terms and conditions is presented. And it said that they do not sign up any of their customers. So every customer makes their own account unless, as my counterpart said, they're part of an enterprise management plan where GigSmart is actually managing that customer's account for them. That did not occur here. The only evidence heard in rebuttal was Axel Hire's testimony that, well, we didn't sign up for this service, GigSmart did it for us. The court, in weighing the evidence, found that sole testimony in response by Axel Hire was not credible, and then it found an enforceable contract existed based on the weight of the evidence.
Yeah, and Axel Hire is saying, okay, throw that away.
Right.
Get rid of that the evidence that GigSmart presented still wasn't good enough.
Right. And we disagree with that. We think we've presented evidence, GigSmart presented evidence of the sign-up process, what that looks like for every customer.
Well, but they did say there were sometimes exceptions, and they didn't have that email that you get when you sign up, right?
Well, so there was an email sent. There was an email in the record that was sent from GigSmart to Axel Hire that afternoon, like 15 minutes after the phone call. And 2 of the people that testified, Mary Jackson and Rich Oakes, were both on that phone call. Mary Jackson says, GigSmart signed us up. Rich Oakes says, I was on that phone call. We never said we would sign them up, and we don't do that. Mm-hmm. And so the court found that there was a sign-up process. It saw what it looked like, and it said, we think you guys signed up, you know. And so we think that's enough, and we think under the standard of review, while we admit all legal issues are subject to a de novo review, but when there's testimony of witnesses, weighing of the evidence, credibility determinations, that's afforded some deference by the reviewing court in order to...
And I agree with you that it is afforded deference. What I understood the argument to be was that although there was an adverse credibility determination with regard to Jackson, that your client had failed to establish that Axel Hire had actually done the sign-up themselves. And there was this discussion in the argument with regard to technology.
Correct.
Okay. So how would you address that?
Well,
So I'm going to phrase it a little differently. The way I understood it is that the adverse credibility determination against Jackson was not supported by the record because the record didn't show that Axel Hire, in fact, had done its own logon and creation of the account.
I see. So the first way I'll respond to that, Your Honor, is GigSmart presented evidence of what the sign-up process looks like. They presented evidence that the account was created by a California IP address, which is where Axel Hire is located. GigSmart's located in Colorado. The account was created within 15 minutes of the phone call that everybody was on. Axel Hire received an email within 15 minutes of that phone call. I think it is sufficient, based on that for the court to conclude that Axel Hire did indeed create that account. And then separately, Axel Hire went on, a sophisticated commercial entity went on to use that account to hire over 1,000 workers repeatedly. And to stand here and tell this court that they didn't understand that they were subject to the terms and conditions of an application that they used over 1,000 times is somewhat ludicrous.
Well, the terms and conditions didn't show up every time they got on the website, right?
That's correct. The distinction is when you create your account and you're presented with the 4 options of different ways to create your account, whether that's an Apple account, a Google account, I believe a Facebook account, or an email account. The terms and conditions is hyperlinked right above that. But if you're coming to log in after an account has already been created, you don't see it.
Right.
It's not that type of presentation.
So
Are you saying that use of the account is the same evidence, is the same thing as actually having agreed to the terms and the conditions and having reviewed them?
It's 2 separate things. So we derived that from a second district case which analyzed the terms and conditions, whether somebody assented to terms and conditions based upon repeated use. And I think in the case of a sophisticated commercial entity who likely also has similar terms and conditions with its own application, to say that they didn't understand that was part and parcel of what was happening, I think is disingenuous. So I think there was sufficient basis for the court to find what it did. And the only way to overturn that determination is for this court to substitute its judgment for that of the trial court, which under prevailing law would not be appropriate. The second issue that Axel Hire brings up is that even if there is an enforceable contract, that the choice of law clause between these 2 commercial entities is just somehow unenforceable. The reliance on Barrett is misplaced. It's a 30-year-old 8th District case. There are a number of cases between that case and where we are now, one of which was Celebration Suzuki. But even more importantly, in 2011, the Ohio General Assembly enacted RC 2307.39, which provides that a form selection clause between commercial entities is presumptively enforceable regardless of whether the contract at issue bears a reasonable relationship to Ohio. If 2 things are present: 1, the agreement calls for Ohio law, and 2, the parties agree to jurisdiction in the contract. Both of those things are present in the contract. So, and I will say,
Do we still have to do a reasonableness determination? I mean, you can't pick like Guam or something as your forum, right? We have to determine if it's reasonable, and it sounds like the argument is that we turn to the Barrett factors to figure out reasonableness.
That's what Axel Hire has said, Your Honor. We don't agree with that. There is only one case, and we didn't cite it in our brief. There's one case that's cited 2307.39 since its enactment. And I think that it speaks to the fact that this is not a complicated statute. It says if you have sophisticated commercial entities and they agree to something, we're going to enforce that. It's not as if there's a consumer is involved here. But
there's no reasonableness analysis? Is that what you're saying?
Well, based on the statute, no. The
statute doesn't seem to talk about that, but the Kennecorp case does.
It does. And my argument there would be that the Kennecorp case preceded the statute by over 20 years.
So you're saying to this court that we don't have to look at reasonableness at all?
That's correct, Your Honor. If you're just looking at the statute, I believe there's not a reasonableness analysis. If the court wants to look further, I believe Celebration Suzuki is appropriate. And to the extent that my counterpart relies upon the Barrett decision, The Barrett decision involved three individuals who did not reside in Ohio challenging retirement benefits. And the forum selection clause in that case called for the forum to be in New York rather than Ohio, and they tried to sue in Ohio. So it's not even, it's very distinguishable from this case.
So can you, okay, assuming that we do need to look at reasonableness, just assume that for a second. I know you disagree. But tell me, if we're not looking at the Barrett factors, what are we supposed to look at, and how is this reasonable?
Sure. Yes, Your Honor. So the Celebration Suzuki case, which cites to a more recent Ohio Supreme Court case, says that unless something is gravely and manifestly unjust or unreasonable, then it's enforceable, especially between commercial entities. So I think in there were also mentions of fraud and overreach. There's no allegations of fraud in this case. There's no allegation that anybody was tricked or lied to. It's really, they're saying that the enforcement of this provision is unfair. They're a sophisticated commercial entity that does business nationwide. They admitted in the record their operations are not confined to California. They hire drivers in at least 5 states, one of which is New York, which is further from California than Cincinnati. And they haven't said how litigating here in Cincinnati would be any different than litigating in Colorado. Where
Are you just saying that if you're a sophisticated corporate entity, and say your business isn't all 50 states, it's confined to 10, then you can be forced to litigate in a state that you don't do business in and the other side doesn't do business in, just by virtue of a forum selection clause? That's what you're saying. You can pick any state.
I believe under the prevailing Ohio law in this statute that yes, Your Honor, that's the case.
No connection needed.
No connection needed. But in this case there is a connection. GigSmart was founded here.
Okay.
It was based here. And I think what my counterpart is advocating is that every time a business moves, they need to change all of their contracts and make sure it's updated with wherever they move to, and I don't think there's any principle of law that says somebody has to do that.
Would it matter if GigSmart only operated, I'm sorry, not GigSmart, Axle Hire only operated within California?
I think that would give them a greater connection to California, but under the analysis called for by the statute, I'm not sure it matters. And so I think in order to grant the relief requested by Axle Hire on this issue, I think this court would have to disregard the statute entirely. The final issue I'd like to direct the court's attention to is the anti-suit injunction. This is a method that's recognized in the Sixth Circuit and by the United States Supreme Court as the primary appropriate remedy to enforce the forum selection clause. It's based on the court's equitable power. There are not many Ohio cases on this issue. Ohio jurisprudence recognizes 4 instances where this is appropriate, where there's a threat to the court's jurisdiction, to promote the public interest of enforcing choice of law provisions, to prevent multiple suits, and to prevent vexatious litigation. I think 3 of those 4 factors, save vexatious litigation, are present here. Axle Hire filed a suit in California shortly after this suit was filed. There is a choice of law provision involved here, and there is an interest in preventing multiple suits. And actually, the California court agreed, and it granted a stay in that case, finding that there was an enforceable contract between Axle Hire and GigSmart that contained a choice of law provision. So I think that recognition, is important in this case. The standard of review for whether the injunction was appropriate is abuse of discretion. In one of the arguments my counterpart brought up in the brief was that it was not consolidated with a trial on the merits, and because of the unique facts of this case, there's an arbitration pending, right? The only issues to be determined at that time were whether there was an enforceable contract, whether the court had jurisdiction, and then whether the matter was arbitrable, right? So there are issues on the merits that are still left over because they have to be arbitrated. But the court did find on the merits that there was an enforceable contract, that it did have jurisdiction. So I think that with regard to their challenge on that issue, I mean, it's not really challengeable here.
You're saying this was not a final appealable order?
That's part of our argument, yes. We think that they still have final remedies available to them.
But not on this injunction. I mean, how else are they going to appeal the fact that they can't do anything right now in their California litigation?
That's correct, but they haven't really lost anything, Your Honor, and that's why I brought up the fact that the California court agreed. So even if they were to go to the California court right now, the California court agrees that there is a contract with a choice of law provision for Ohio.
No, it's not a final order. I mean, they want to do their litigation in California, and they can't do it because of this injunction.
Mm-hmm.
How else are they going to appeal this injunction? Unless, I mean, it seems like they have no other remedy but to come to us.
I understand, Your Honor.
Because it's not like there's a permanent injunction that's going to be entered later, right?
Right.
It's just until arbitration's complete.
Right. In the arbitration decision, they would be able to challenge the arbitration decision when it's adopted by the trial court. They would have a right of appeal at that point.
And then I take it the preliminary injunction would get lifted at that stage?
I believe so, Your Honor.
Okay.
I believe that's all I have, if the panel has any questions.
Okay. Thank you very much.
Thank you very much.
You have 3 minutes.
Thank you, Your Honor. I'll try and stick to my time this time.
Well, that was my fault.
I want to start with the concept of the reasonableness analysis. Gixmart's position is there isn't one. Then they point the court to Celebration Suzuki, which has a reasonableness analysis, and in which this district court said it would arguably be unreasonable if the parties designated a forum where there was no connection, which is exactly what happened here. Then Gixmart proposes to the court that it supersede 30-plus years of jurisprudence, Ohio Supreme Court jurisprudence, overrule all of it on the basis of 2307.39. All due respect to the Ohio legislature, it can't overrule the 14th Amendment through statute. It can't waive due process requirements on behalf of foreign entities. And I don't think that's what it was trying to do. I think it's saying that these provisions are valid in a contract, but that's a separate analysis from the due process personal jurisdiction analysis.
I want to read you something that the 8th District wrote, quoting a unpublished decision from this court. It says, here the contract was an employment contract rather than a contract between two sophisticated business entities. And then it says in this First District Court of Appeals case, it held that although the employment contract contained a forum selection clause, the contract was not a commercial contract requiring enforcement without looking at the other factors. So my question for you is, how do you distinguish this case, and this is Zilbert, from the current case?
Zilbert was saying if it's a commercial contract, then we don't look at any other factor?
Correct. At least that's how I interpreted it.
I don't have that provision in front of me. I don't have the Zilbert decision in front of me. But if that were the holding, it would be incorrect. It would be in violation of Kennecorp. It would be in violation of the litany of cases cited by both sides, Preferred Capital, Inventive, which postdates 2307.39 and still applies a reasonability analysis to a case involving two commercial entities in a commercial transaction. And notably, it was not argued below by Gixmart that 2307 applied, and the trial court didn't address 2307 either. I see my time has expired, so thank you very much.
You have like 30 seconds.
I have 30 seconds. I will very quickly
Yeah,
address
wrap
the
up.
anti-suit injunction in 30 seconds. There were no findings whatsoever as to likelihood of success on the underlying claim, and there is no case where an Ohio court prevented a foreign entity from seeking redress in its own state. All the decisions cited emphasize that this is an equitable power based on the court's ability to restrain its own citizens. And that's something the California court recognized as well, that you can't reach out and stop citizens of other states from using their own courts. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted. You'll get us the exhibits that we need, and we will issue a timely decision. So have a good rest of your morning.
It's good to see you, Mr. Rest.
Good to see you.
All rise.